And then we'll start the process again on letters and subpoenas and accommodation. And I've just grown tired of it. And I think you're right, Ms. Foley, that this is all professional wrestling. There's no real effort to bring these people to bear.
That the conduct of the judge was the exact opposite of bias.
Well, I think when you piece all those pieces of evidence together, they paint a pretty compelling picture of bias.
Is Trump in one of those nesting dolls underneath Putin?
It's debunked. It's a conspiracy theory.
Said that the DOJ should be viewed as above reproach because, look, they prosecuted the president's son. A year ago, weren't they cutting a sweetheart deal?
It's President Trump today. Who will it be tomorrow?
Sounds like he's an ambassador, not an ambassador. Is everything that could influence a campaign finance expense?
Well, under Mr. Bragg's interpretation, it would be, but under normal campaign finance law, it would not be.
Mr. Eisen, what you've just stated is so utterly and completely absurd, it's almost impossible to even respond to it.
And I couldn't believe, as an American who grew up in tyrannical country, that we would be sitting here and the system of media collusion with our justice system.
May I return the Russian doll?
You have to be specific about elements of the crime. That's what the court said in Shad.
Guilty, 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 guilty.
We are here at the hearing on the Manhattan District Attorney's Office, and the essential ingredient we seem to be missing is the Manhattan District Attorney, which I guess, Mr. Roy, would be a lot like going to the Salt Lick Barbecue and not getting the moist brisket. Now, to Mr. Jordan's credit, great credit, he sent a letter to Mr. Bragg on May 31st inviting him to come participate, and we got sort of a nasty gram back from Mr. Bragg on June 7th. Mr. Chairman, I seek unanimous consent to enter into the record the June 7th response from AG Bragg.
Objection.
And, I'm sorry, DA Bragg. And in this letter, I'm going to quote from it, Ms. Foley. Bragg says, "This office is committed to voluntary cooperation." Do you believe that?
No.
The letter continues, "That cooperation includes making the district attorney available to provide testimony on behalf of the office at an agreed upon date." Do you believe that?
I'll believe it when I see it.
It goes on to say that they're evaluating the propriety of allowing an assistant district attorney to testify publicly about the matter. Now, that assistant district attorney is the one who downstreamed from DOJ, right? So you think they're going to provide Mr. Colangelo here to answer our questions?
I would not expect Mr. Colangelo to show up.
And do you base that opinion on the lawsuit that Alvin Bragg filed against Jim Jordan in his official capacity in the Committee on the Judiciary?
I saw some of that, yeah. I mean, look, you have a legitimate legislative purpose to be inquiring as to what you're doing, so they have no leg to stand on.
But they're not going to come because we ask. And they're not going to come because they say so. And we learned that by observing our dear friends at the Oversight Committee. Because this will surprise a lot of Americans. After hearing the enthusiasm around oversight of the Biden crime family, we never sent a subpoena to Hunter Biden to give live testimony before Congress. Let that sink in. The Republican House majority has never subpoenaed Hunter Biden for live testimony in public. We've never done it. And I worry that, we're going about the same kind of process here, and we may end up there in July, right after sentencing, with an empty Alvin Bragg nameplate and an empty Matthew Colangelo nameplate. And then we'll start the process again on letters and subpoenas and accommodation, and I've just grown tired of it. And I think you're right, Ms. Foley, that this is all professional wrestling. There's no real effort to bring these people to bear. So,
Will the gentleman yield for a
no,
question?
one second, I got a motion. Mr. Chairman, I move under Committee Rule 4 and Clause 2M of House Rule 11 to require the attendance and testimony of Alvin Bragg and Matthew Colangelo on July 12th to discuss their involvement in the Trump prosecution, including their office's coordination with the Department of Justice.
Mr. Chairman. Mr. Chairman.
Gentlemen, ranking members recognized.
It's a little absurd because Mr. Bragg and Mr. Colangelo have already agreed to appear before the committee on July 12th. We have a letter to that effect, so there's no point requiring them to do what they've already said they're going to do. The committee asked them for to appear. They asked them to appear today. They made the point that they did, or Mr. Bragg, I should say, made the point that he didn't think he should appear before the sentencing on July 11th, but he'd be available thereafter, and he's agreed to come on July 12th.
Mr. Chairman, this debate's out of order.
You made a motion. It's not out of order.
No, you have to seek recognition pursuant to debate on the motion. You can't just inject.
I recognize you.
I'm still on my time. I'm still controlling 2 additional minutes of time.
You'll get your time, man.
I have a letter here. No, my point is simple. The committee requested them to appear, Mr. Bragg and Mr. Colangelo. They've agreed to appear. They plan to appear on July 12th. I don't know what this debate is about. I yield back. Oh, and I'd like unanimous consent, Mr. Chairman. Yes, unanimous consent to introduce into the record a report from Fox News headlined.
Without objection.
I object pending consideration of my motion.
Hang on, I want to deal with.
Let me finish.
I want to deal with Mr. Gates' motion. Then we'll take your unanimous consent. Mr. Bragg and Mr. Colangelo have agreed to come on the 12th. If they don't show up on the 12th, they will be subpoenaed. So I would ask the gentleman if he could withdraw the motion. They're coming. We worked hard over the weekend to make sure they're coming. And if they change their mind, they will get a subpoena from the committee requiring them, compelling them to be here. And then if they choose to go to court on that, I think we'll beat them in court like we did the first time when we got Mr. Pomerantz to come testify in front of the, come be deposed in front of the committee.
Time then becomes determinative. The problem is, if we're going to bring these people in, let's go. I've made a motion to subpoena these people now pursuant to the rules, and I want to vote on my motion, or I want someone to move to table it.
You made the motion to subpoena them for the 12th?
I moved under Committee Rule 4, Clause 2M of House Rule 11, to require the attendance.
I move to table the.
That's fine.
I
Let's take a
second
vote.
that.
That's not debatable.
Gentleman's made a motion. The motion to table is not debatable. Those in favor of committee will stand in recess.
Chairman, I will withdraw my motion based on the representations, not only that you've made, but that the ranking member has made in our colloquy previously, that Mr. Bragg and Mr. Colangelo will be here and willing to answer our questions.
Correct.
Gentleman yields back. Gentleman from New York is recognized for 5 minutes.
Thank you, Mr. Speaker, Mr. Chairman. Ambassador Eisen, I want to talk about some of the disinformation that's been spread about the trial in New York. Republicans have attacked Judge Merchan as biased and have suggested that he continually ruled against Trump. What is your response to that allegation?
Mr. Chairman, I was present throughout the trial, and I thought that the conduct of the judge was the exact opposite of bias.
Why are Republicans going to such lengths to attack these prosecutors? And what are the benefits of delegitimizing them?
Because Mr. Trump is guilty of interfering in the 2016 election and covering it up with 34 false documents. And because the American people understand that that is a disqualification for a public figure in our country, and because that pattern was exemplified again in 2020, is a threat for 2024, and these attacks on prosecutors, juries, judges are of a piece with Donald Trump's promise to be a dictator on day one. That is why they are
Gentleman's-
pushing back.
If a prosecutorial agency is actually searching for crimes because of an individual, and they've stated it, don't forget Mr. Bragg, and I'm leaving out all of his campaign promises to get Trump. Couldn't name any kind of thing that he had done wrong, but he's going to get Trump. Is that antithetical to the very notion of due process in and of itself?
Yeah, you ask a really interesting question. Yes, the short answer is yes. There is a line of Supreme Court jurisprudence beginning with a case called Rochin versus California in the 1960s, which establishes what's called the shocks the conscience test for violation of due process. You may remember that from law school. It's where your stomach got pumped forcibly against his will.
Yeah.
But since Rochin was decided, there have been other Supreme Court cases. There's one called Exrel Vuitton. There's one called Caperton involving judges. And this line of jurisprudence under due process says that if you can establish that there was bias by a prosecutor, an investigator, or a judge that shocks the conscience, it's a due process violation as well.
Right, so when we start looking at this, and you realize that there was no theory of the case that seemed to work. I mean, that's from Mr. Pomerantz's testimony. They couldn't come up with a case. You have prosecutors saying, we just we can't find anything here. And then all of a sudden you get jury instructions like you have here. How antithetical to that is to due process?
Well, I think when you piece all those pieces of evidence together, they paint a pretty compelling picture of bias and, whether or not it would shock, the left side of the aisle's conscience, I don't know, but it certainly would shock mine. I'm trying to be pretty objective about this. It's a high bar to shock someone's conscience, but, basically the idea is, if you're doing the Attorney General Justice Jackson maneuver of picking the man and pinning some crime on him, then yes, I would hope that would shock your conscience.
What kind of job did he, what you saw and what you have heard from others, did he perform?
I thought that everyone in the case, including Donald Trump's own defense lawyers, who I praised, I wrote a daily trial diary published, and I dedicated one to singing their praises myself as a
Merchan was highly rated.
Merchan was one of the great judges that I've seen.
Thank you. I've got it. Ms. Foley, one question. Is Trump in one of those nesting dolls underneath Putin?
Where? What? Which?
That's the ones I've seen. I yield back the balance of my time.
We always thought this couldn't happen here, but it has. And my question is what can be done by Congress, first of all, to close this Pandora's box and assure that it is never opened again? Mr. Bailey?
I think this body has a duty to erect a wall of separation between tech and state to prevent government censorship of conservative voices on big tech social media platforms. As you pointed out, the deep state has actively suppressed information that interfered with the 2020 election. I think that will continue to happen as we move into 2024. And I think the distinguished member is absolutely right that we've got to stop looking at lawfare in terms of trees and start seeing the forest for what it is. It's censorship. It's civil suits. It's President Trump being unconstitutionally stricken from the ballot in states. It's now criminal charges.
It's the turning of the most terrifying powers that government possesses against its own citizens to influence elections. And this has been going on now through several cycles, and now it's getting to a whole new level. Mr. Trainor?
Thank you for the question. I think it really comes down to the fact that we have to get away from allowing government to be the weapon to interfere in political participation.
How do we do that?
I had the opportunity last year to testify before the House Administration Committee on this very issue of how complaints are filed with the Federal Election Commission and used to do nothing but go investigate political opponents under the guise of the federal government conducting a legitimate investigation, and they ultimately turn out to be nothing at all. In fact, the most infamous one that I talked about was a gentleman who spent $348 on a Facebook page. The allegation against him was that he had spent $23,000 on a Facebook page, and he spent 3.5 years being investigated.
Right, and word gets out to anybody else, don't even go near the political process because you will expose yourself to this kind of liability.
I want to read from your testimony. They have sat idly by and allowed a state officer to assert federal jurisdiction where they themselves had taken jurisdiction and couldn't prosecute. I want you to unpack that sentence for us again real quick.
Thank you, Mr. Chairman, for the question. The Department of Justice, all of these claims with regard to the $130,000 from Ms. Daniels stem from a complaint that was filed at the Federal Election Commission following the 2016 election.
Which you guys were investigating.
We were in the process of investigating that.
And the DOJ came to you and said, stand down, we're taking over, and give us your information.
They asked us to abate that and several other
DOJ
matters.
meeting the Southern District of New York.
That's correct.
They took your information, and you guys said, we voted to stand down and give it to the federal authority, right?
That's correct, Mr. Chairman.
And they determined that there was nothing there to prosecute other than Michael Cohen.
That's
the star
correct. Now,
witness in
they
this
took
campaign.
they took a very long time in doing it, and when they sent it back to us, we had no more authority to investigate because they sent it back to us, and we were barred by the statute of limitations from even investigating the normal civil things that we would look at with regard to those type of expenditures.
But your point here is they've said idly by and allowed a state officer to assert federal jurisdiction where they themselves had intervened, to use a word, and taken jurisdiction from you and concluded there was nothing there regarding a federal statute, right?
That
and
is
a, quote, federal crime that they come up with somewhere.
That is correct, Mr. Chairman, and I don't know what role Mr. Coangelo played in that investigation that took place when they took it away from the Federal Election Commission, did that investigation, and then he later left the office to go prosecute this at the state level.
Well, we're going to find that out on July 12th when Mr. Colangelo will be sitting in your seat, Mr. Bragg will be sitting in Ms. Foley's seat, and we'll get a chance to ask him.
MAGA Republicans are trying to make the American people believe a false narrative, that being that Alvin Bragg, a state prosecutor, was somehow manipulated by federal officials, Biden officials, Justice Department, to prosecute and persecute Donald Trump. And the fact that this committee, the Judiciary Committee, is trying to get Americans to buy into this false narrative is concerning. Wouldn't you say so, Mr. Eisen?
It's deeply concerning. It undermines Americans' faith in the rule of law, in the Department of Justice, which has been quite independent from President Biden, and it's baseless. There's no evidence for it. It's debunked. It's a conspiracy theory. The ranking member just entered the proof into the record submitted by the Department of Justice. More proof. It's wrong.
Mr. Eisen, I just want to make sure you answered the ranking member, I think, and I want to make sure I heard it correctly, that you said President Trump's interference in the 2016 election.
Correct.
Is that correct?
That's correct.
That he interfered in the 2016 election?
Yes, sir.
And real quickly, how so?
The jury unanimously found in the Manhattan case that former President Trump had committed 34 felony violations of document falsification.
You weren't referring to anything else?
No, that's not true. That's disinformation, sir.
Yeah, okay.
In order to find that, they were charged with election interference. The underlying crime that made that a felony, not a misdemeanor, was election interference. Same pattern as 2020.
So it's all about election interference in 2016 also. Ms. Foley, so we heard from the gentleman that's to your right that he said that the DOJ should be viewed as above reproach because, look, they prosecuted the president's son. A year ago, weren't they cutting a sweetheart deal? Do you recall the details of that?
Yeah, I mean, they were basically just going to let him walk for all of them. They already allowed statutes of limitations to expire on multiple of the more serious felony.
So how did that happen that we actually may get justice in that case?
Well, I mean, look.
Wasn't it the judge that threw out the sweetheart deal?
Yeah, I mean, you had a judge in Delaware that threw out the sweetheart deal, yeah. And then, I guess there was egg on the Biden administration's face, so they felt like they had to do something, so they pursued these current charges, the gun charges and the tax charges. But, I mean, did they reach the right result? I assume so. I didn't follow that trial very much. I think there'll be an interesting question as to whether the president commutes his son's sentence, so we'll see.
In fact, I believe it was Governor Hochul after this charge happened, went on media in New York and said, hey, don't worry, this isn't going, we're not coming after the rest of you business people. This is just Donald Trump. Talk about the impact of something like this for the long run in the rule of law?
The Constitution is our national identity. Those rights codified therein come from God, not man, and the document is intended to protect us from the government. And yet what we see time and time again is the government being weaponized against individuals. It's President Trump today. Who will it be tomorrow? And that's the problem. I think that when you look at the due process issues contained in the charging document, ultimately in the jury instructions, and you look at the inchoate nature of the offenses with these ill-defined levels of attenuation, it's as if invisible links of chain are necessary to connect the facts to criminal liability. And it causes the jury to turn into a roving commission, free to pursue whatever facts they want to attach liability as they please. And the issue there is it undermines the rule of law for the rest of us. Who can have confidence that we know what is and isn't illegal behavior when the court and the prosecutor impanel a roving commission to attack a political opponent?
I want to begin by quoting the jury in the Manhattan hush money payment trial. Guilty, 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 guilty. This was what the jury pronounced unanimously on every count. My Republican colleagues don't really contest Donald Trump's guilt. This is the fascinating thing. Their argument is essentially he should never have been prosecuted, or they falsely claim it was a political prosecution, or they falsely claim it should have been a misdemeanor, not a felony. But they don't contest, not really, that Donald Trump was making hush money payments to a porn star to hide their affair from voters. What they're really saying is they're more than comfortable nominating and electing as the President of the United States someone making hush money payments to a porn star. The party formerly of the moral majority is now, I suppose, hoping to fashion some kind of immoral majority to reinstate Donald Trump as president. The presidency, the most powerful office in the world, and not the most powerful because of the size of our military, but because of the power of our ideas. And what is the animating idea of a Trump presidency? It is dictatorship. It is power at all costs. And this is also tragically the animating idea of the Republicans on this committee. Power at all costs. What else can explain what it would profit them to give up their political soul but a world of power?
This is amazing construction of some kind of crime here, but when we dig down to the bottom of it and try to find out what the underlying crime is, I don't think that's been discussed enough, or what the supposed underlying crime is. One of the propositions was that hush money should be reported as a campaign finance expense. Okay, if somebody pays their attorney to seal divorce records because they may be going to run for office or they are running for office, Mr. Trainor, is that a campaign finance expense? Is that something you see on campaign finance reports?
That is not. It is something that you would see, legal fees are often reported, and it has been the tradition at the commission in looking at those legal fees that we don't question what the attorney-client privilege between the candidates and the lawyer are of what's needed in those particular circumstances.
So let me use another example. In 1999, Bill and Hillary Clinton bought a house in New York, obviously influenced the election of the Senate race there in New York because they moved into the House so that she could run for Senate. Is that a campaign finance expense? Is everything that could influence a campaign finance expense?
Well, under Mr. Bragg's interpretation, it would be, but under normal campaign finance law, it would not be. There are distinct similarities here between the John Edwards prosecution in 2008, where he paid over $1 million to his mistress to keep her quiet, and was prosecuted by the Department of Justice for that, and was ultimately acquitted on 1 count and had a mistrial on all 5 counts. Because the jury was given a correct charge as to what the federal law was. In this particular case, the jury was given an incorrect jury charge as to what the law is, and they come out with a completely opposite ruling.
Yields back to gentleman from Kentucky.
Mr. Chairman, I have a unanimous consent request. Ask unanimous consent to submit for the record an article in Open Secrets that says that Ambassador Eisen bundled between $200,000 and $500,000 to the Obama campaign. Sounds like he's an ambassador, not an ambassador.
Did President Biden say repeatedly, and did the Biden administration repeatedly declare the Hunter Biden laptop Russian disinformation?
I am not an authority on the statements or on the laptop.
I mean, come on. Was that not repeatedly stated by the President of the United States and the President's campaign? For example, did President Biden not say in a debate, look, there are 50 former national intelligence folks who said that what he's accusing me of is a Russian plan. They have said this has all the characteristics. 5 former heads of the CIA, both parties, said what he's saying is a bunch of garbage. Nobody believes it except him and his good friend Rudy Giuliani, and they go through and talk about it. Was that not a central feature of the campaign in 2020 by President Biden?
I do think it's very important to distinguish between the vigorous debate that we've seen here today, extremely vigorous, and a violation of
Was Hunter Biden convicted this week based on evidence obtained in that laptop?
In part, yes.
Yes. Hunter Biden was convicted this week in information that was brought out from that laptop, which President Biden and his campaign repeatedly referred to as disinformation in the 2020 campaign. So the former president is or is not guilty, or is not, engaged in activity that could be described as election interference.
There's a difference between falsifying documents to cover up and scheme to interfere with an election by, if I may finish my sentence.
No, it's just my time.
There is a difference between breaking the law and political debate.
Okay, so let me ask you this question. What is the first date of a crime that is alleged to have been committed by President Trump? The actual date of the crime.
The date of the initial crimes were when the conspiracy to interfere with the 2016 election was formed in August 2015 at Trump Tower, when David Pecker, an independent witness, testified that he, Mr. Cohen, and Mr. Trump agreed on a conspiracy to violate New York law.
Was it not the crime that Alvin Bragg alleged first committed was on February 14th, 2017?
That is
the actual crime?
That is when the cover-up occurred. That is a different element of the crime. The conspiracy began August 2015.
The fact of the matter is, and for what? Are NDAs illegal?
When an NDA is used to facilitate an illegal campaign contribution, over $127,000 in excess of the legal limits, yes.
Well,
it is a means. It is an unlawful means.
As the gentleman from Kentucky just pointed out, the absurdity of that assertion is plain based on what he was just making in his case. But the fact is, you have in February of 2017, well after the 2016 election, the first crime that is even referenced in what the district attorney Bragg was doing.
Why is it important for democracy that presidents or presidential candidates, no matter what party they come from, be accountable for their crimes and not be held to be above the law?
Ms. Ross, it's the fundamental American idea. We were speaking earlier of the proud history of our country with all our challenges over the centuries. We overthrew a system and a king, George III, where one man was above the law. In his place, we put the Constitution and the founding American principle: no one is above the law. If Donald Trump, as the jury unanimously found of 12 of his peers, covered up 2016 conduct of a pattern that we saw again in 2020, we see him limbering up for in 2024, then he deserves to be found guilty. If 10,000 other cases, approximately, in New York since 2015 have resulted in prosecutions, he should not be held to a different standard when he falsifies business records to cover up another crime. That's what America is. That is why this verdict was so important.
And again, Ambassador Eisen, do you think that the Obama administration was correct in not interfering in the John Edwards prosecution?
I do. You correctly point out that case relied on the testimony of a former campaign aide, Mr. Young, and his wife, Sherry. Weak witnesses, contrary to what we saw in New York, witness after witness, document after document. An overwhelming factual and legal case that will withstand appellate review.
Mr. Eisen, what you've just stated is so utterly and completely absurd, it's almost impossible to even respond to it. This case will be reversed on appeal. The level of egregious reversible error that was demonstrated by this judge and by the prosecutors is absolutely off the charts. I've never in my entire career seen anything even close to it. I think you recognize that. I think the vast majority of the American people recognize that. I really want to focus on the equal protection and due process issues that are so clearly evident here. And the fact, Mr. Eisen, that you keep going back to 2016 and what occurred in 2016 is extremely important from that standpoint. Ms. Foley, is there a due process and equal protection aspects to statutes of limitations?
Well, I mean, statute of limitations can be, I guess, evaded, I suppose, in ways that could violate the due process or equal protection.
Well, and in fact, in this kind of a circumstance, that's what you see. We've got a situation where the alleged crime was committed in 2016, and they had to bootstrap it to something that occurred years later to try to resurrect what was really a dead case. And the way that I look at statutes of limitations as someone who practiced law for well over 30 years is that people have memory issues. That's why there's a statute of limitations. Can you remember what you were doing on June 13th, 7 years ago or 4 years ago? I'm sure Mr. Ambassador cannot. There are statute of limitations because trying to drag somebody before a tribunal 5 and 7 and 10 and 12 and 15 years down the road, by its very definition, especially if we're talking about a potential criminal prosecution where someone is going to lose their freedom, do we really want someone getting up and being able to say, 25 years ago, I was attacked in a dressing room, I have no evidence, can't tell you anything about it, don't even know what day of the week it was, don't know what month, don't know what year, but for goodness sakes, we know what happened. So we have the state of New York, and they come in and they pass a law saying, well, we're not gonna have a statute of limitations for this particular crime or this particular individual. Wouldn't that be considered a violation of this gentleman's due process rights?
Yeah, I mean, I think it's part of the overall context, which again kind of shows the political motivation, the uniqueness of this case. I mean, Ambassador Eisen talks about the 10,000 cases. Well, I've read most of those cases too. None of them approach the uniqueness of this case and the obfuscation of the theory here. For example, usually the underlying offense that is intended to be committed is grand larceny, insurance fraud, things like that. Very straightforward facts. But by making the underlying offense here federal New York election law, which itself required proof of unlawful means, which then hinged upon FICA, tax laws, falsification of business records, it just got more and more and more unclear exactly what Mr. Trump was being charged with. So all of these facts suggest that there is a shocks to conscience due process violation here, in addition to the notice problems I've pointed
Well,
out.
and I think that there's the due process issue, but Mr. Bailey, let's turn to you and let's talk about the equal protection aspect of it. As you've just described, Ms. Foley, this is one case against one man for one purpose. And in fact, the governor of the state of New York has said it. Look, everybody, don't worry. Don't worry, we're not coming after you for these kinds of fraud claims. We're just going after Donald Trump. Isn't that the antithesis of the foundation of our Constitution that is based upon equal protection and equal application of the law? Have you ever seen anything like what they have done to Donald Trump in their effort to destroy who they perceive to be their political enemy? Mr. Bailey.
I have never seen such an egregious assault upon the tenets of equal protection as when government officials in the state of New York claim that they are specifically targeting one individual and will not use the same laws against anyone else. But I want to go back to the due process issue briefly, because everything that's being said here is further amplified by the fact that Section 175.10 of the Code of State of New York, which forms the basis of the 34 charges, has an affirmative defense that requires the defendant to get a preponderance of the evidence. How can he go get his evidence if you bring the claims late? Statute of limitations are intended to prevent sandbagging of claims.
Exactly right.
Just talking about 2016, I think, Ambassador, you made statements about interference in election. What do you think, from your perspective, to have Department of Justice under President Obama at that time, and you're probably very familiar with Durham report, rushing through closing the case for Hillary Clinton without doing any proper investigation, and then rushing through to have Russian collusion hoax against Trump without even vetting any of the information. And it turned out to be all lies, right? We have a report on that. So do you think, from your perspective, and then colluding to cover up with Ms. Media's, like Politico and other one, to cover up the story, isn't it seem like that could be looking like interference in election in 16?
No, Ms. Spartz, I don't believe that. There was ample evidence to predicate that investigation, including the polling data that was passed from Trump campaign manager Paul Manafort to Konstantin Kilimnik.
No, I'm talking about the report. So you think the special prosecutor did not do a good job and he lied in the report? I mean, he actually concluded in his report that FBI didn't do its job, and it was outrageous. He was outraged what's happened in FBI.
He did
Well, it seems strange, but let's go further. The same situation with Hunter Biden in 2020. The same media, political reporters have the story that actually was 50 security, this national security firm advisors, a printed story that Hunter Biden laptop doesn't exist, and give likes to that story, and all media go that, and he's talking a debate, and this is all former, Department of Justice, employees. And then it's going to, in the election, President, Biden as a candidate at the time using it, to cover up and say, oh, it doesn't exist. We know it exists. Doesn't it look strange to you?
The Biden Department of Justice empowered a Trump holdover U.S. Attorney, David Weiss, to prosecute Hunter using the laptop. It's the exact opposite. It's an affirmation of the way the rule of law works.
In 2020, doesn't it look strange that that's a period during election and they have disinformation campaign? The same political reporters are doing again. Doesn't it seem like awfully strange to you? Doesn't it seem like, and it's not interference at all. But I'm not going to probably get an answer because you do have a double standard, and we do have a double standard. And our system of justice is broken. And that's why Americans are intimidated and they're worried about not existing of the rule of law, because we have a rule of law, that working, to protect now, the Department of Justice to protect people that they like. This is a political prosecution. And I'm not going to detail with the case, but it would be intimidated for Americans, and it would be very oppressive and tyrannical. And I couldn't believe, as an American who grew up in tyrannical country, that we would be sitting here and the system of media collusion with our justice system. I think that is very, very sad, and I'm very disappointed that you cannot tell the truth here. I yield back.
Would the gentlelady yield? The gentlelady yield?
I yield. I yield
appreciate gentlelady. Ms. Foley, Mr. Ivey basically said what you told the committee about the jury instructions, he disagreed with that strongly, but was going to let Mr. Eisen answer for you. So I want you to be able to answer for yourself.
Well, thank you. I appreciate that. Yeah, I mean, that's sort of the bait and switch that was going on here. The stuff that he talked about on the prosecutor's response was a response, and then he flipped the page and saw some of the detail. But that's all a response that talks about the first predicate, which makes the falsification of business records a felony offense. All of that information is about this first predicate. But the interesting thing is that all of that detail on the page that he flipped ended up having nothing to do with the first predicate, but the second predicate, which was the basis for the New York election law offense. So all of that detail was useless because all of that detail was about this and not this. In fact, we didn't even know this was necessary until the judge instructed the jury about this New York election law.
That's the point.
Right.
Donald Trump, referring to the 2016 presidential election, claimed, quote, "I won the popular vote if you deduct the millions of people who voted illegally," end quote. Mr. Eisen, Ambassador Eisen, was that statement that millions of people voted illegally in the 2016 presidential election true or false?
Like 30,000, over 30,000 other statements that the former president has made, false.
Thank you. Donald Trump in 2019, referring to the free press, claimed, quote, "Truly they are the enemy of the people." Ambassador Eisen, is the press the enemy of the people, true or false?
Under the First Amendment of the Constitution and the proudest traditions, the Fourth Estate is the pillar of American people, the friend of the American experiment. False. We are in a disinformation and a mis- and malinformation epidemic. I testified about it in my last visit before the committee, and I do have to point out one piece of incorrect information that we heard today, that this theory of the case was never put before Donald Trump until the closing of the jury. I have here, not only do we have the response to Bill of Particulars, I have the opposition to the motion to dismiss November 9th, 2023, putting forth, may I have the middle Russian doll, please?
This one?
Here it is. Look at the document. The Russian doll is in the document.
Not true.
Here it is, page 25, please. These actions violate Elections Law 17-152, conspire to promote the election of a person to public office by unlawful means, including FICA, the falsifying the records of other New York enterprises, and mischaracterizing the nature of the repayment for tax purposes.
Introduce documents into the record.
May I?
But I
didn't ask to introduce it.
The gentlelady.
May I return the Russian doll?
Trustee Foley, you want to respond to the rant we just heard?
Yeah, if I may have this back. Okay, so this opposition to the motion to dismiss, also he gives one page out of context. That paragraph that he was pointing to, these actions also violated election law section 17.152. In other words, it's just regurgitating exactly what they said in response to the requested Bill of Particulars, that the underlying offense, the first predicate, could be one of 4 different statutes, all of which are very, very different and do not provide adequate notice to a defendant, because this is an element of the crime. You have to be specific about elements of the crime. That's what the court said in Shad.
So if I may, thank you for that
That's why there's a
explanation.
due process problem.
Is there a federal reason for us to be looking at a state action such as we observed in Manhattan?
Unquestionably, there's a reason for this committee to investigate this, and it goes back to my opening statement where I talked about the fact that the Department of Justice did not zealously represent the United States in this particular case to go in and defend the jurisdiction that this Congress has given through FICA to the Federal Election Commission and to the Department of Justice to prosecute those crimes. Instead, they abrogated that to a local official to prosecute.
Was President Trump's alleged payment via Michael Cohen to Stephanie Clifford referred to the FEC?
We did have several complaints related to it.
And what did the FEC decide with respect to that referral?
Well, ultimately, we deadlocked on a decision related to it, but the real factor in making the determination was the fact that the Department of Justice asked us to abate those proceedings so that they could conduct an over a year-long criminal investigation, which they determined there was no criminality in, and then they sent it back to us, and it was statute of limitations barred.
So did the Justice Department also decline to charge the former president for charges related to FICA?
They did.
Right. And so the two agencies that are charged by Congress to determine whether President Trump's payment constituted a violation of FICA found no violation and took no enforcement action. Is that correct?
That is correct.
All right, thank you very much. Ms. Foley, you argued in a recent Wall Street Journal op-ed that Judge Merchant likely denied President Trump a meaningful opportunity to be heard by denying the testimony of former FEC Chairman Brad Smith. Can you please elaborate a little bit on that?
Yeah, I mean, there's been a lot of sort of misreporting on what happened here. Yes, Judge Merchant, as my colleague, Mr. Eisen, points out, did allow Brad Smith to testify, but the catch was he could not opine at all, either provide his opinion or any personal opinion or legal opinion regarding whether or not President Trump's actions had violated FICA, which was basically, then he was useless, which is why President Trump didn't call him as a witness. So the whole point was President Trump wanted an expert witness to put before the jury to show the jury that what he had done did not, in fact, violate federal election law. And he was denied that opportunity, and that seems like a rather basic thing that he would have the opportunity to be heard on.
Do you think there was a chance that he could have had success upon appeal?
Will he have success on appeal of this? Yeah, sure, absolutely. I mean, the thing is that, you know, again, I agree with Norm on the fact that the bias issues are difficult to win because they get deferential standards of review. But the due process issue is a question of law. It gets de novo review. The appellate courts get to look at it fresh, with fresh eyes, no deference whatsoever. And more importantly, due process issues are issues that the Supreme Court can ultimately grant cert and hear.
Did Alvin Bragg's indictment actually articulate a provable felony offense?
Did the indictment?
Mm-hmm. Yes,
no.
ma'am.
I mean, the indictment was about as generic as you could get. I mean, one of the primary elements is the intent to commit another crime. The indictment said nothing about that. And he provided a statement of facts that accompanied the indictment. That also said nothing about what that other crime was.
Why do you suppose that was, that it omitted that?
I think to the extent that you want to convict someone, you hide the ball, you obfuscate, and that keeps the defense counsel on their toes. They don't know what evidence to put forward to the jury. It's an ever-moving target. It makes it very difficult to defend if you're a defense counsel.
And how does that impact the jury instructions in the end? You talked about that, but I want you to discuss that again.
Yeah, well, you don't know till the end, if you don't know till the end, what exactly the first predicate is. You don't know who to put on the stand. You don't know what evidence to put forward. The only reason he tried to bring forward Brad Smith, for example, the former FEC chair, was because Alvin Bragg kept hinting that maybe one of the bases for the first predicate was the FICA violation. And so he kind of knew that, so he tried to get a witness to say something about that, and he was denied. So it was just an exercise in futility for Trump to try to defend this case because it wasn't clear exactly what he was being charged with.
Thank you for that. And just changing gears a little bit, who's Matthew Colangelo?
Well, he was, the number 3 guy in the Department of Justice?
Correct. And what is his current title? What does he do now?
He's on Alvin Bragg's prosecutorial team. I'm not sure exactly what his title
At a
is.
state DA?
Yeah, state DA, that's correct.
Is that unusual to see somebody go from, the number 3 position at the Department of Justice to a state district attorney?
I know some other members of the committee have suggested, well, you do it out of the goodness of your heart because you're a public servant and all that jazz. And I'm sure that's true, but at the same time, it's exceedingly unusual for that to happen, for you to take a downward movement in your career. And because of the unusual nature of it, it makes you go,
The whole purpose of my testimony was to highlight the fact that the jurisdiction that was asserted here is jurisdiction that belongs to the Federal Election Commission that could ultimately then refer it to the Department of Justice.
Do you believe the Justice Department should have intervened to protect both the FEC's jurisdiction and its own?
Without question.
And did the Justice Department intervene?
They did not. They only intervened in the Federal Election Commission's investigations.
So in other words, the Biden Justice Department allowed the Manhattan DA's office to usurp both the Justice Department and the FEC's jurisdiction, correct?
Absolutely.
And tell us, why is that problematic?
Well, it's problematic because it sets up a system. Well, first and foremost, it allowed the judge to get the law wrong in this particular case and issue a jury charge that had to do with willful contributions as opposed to knowing and willful contributions, which is what the law requires to be proven. But in a larger picture, it sets up a standard where you can have 50 different states trying federal election crimes under various standards.
Without objection, the hearing is adjourned.